In the American justice system, courts and prosecutors are bound by one central principle: they cannot make up the law as they go. They must work within the framework of existing statutes, constitutional protections, and binding legal precedent. But in Tennessee's 19th Judicial District, recent filings by Assistant District Attorney Jason White reveal a troubling story. One of motions unsupported by law, hearings held without the defendant present, and gag orders that tread directly on the First Amendment. Here, we see the defendant's motion to appear electronically, a reasonable and timely request. He had relocated to Colorado and explained he could not afford repeated travel back and forth. The Constitution guarantees defendants the right to be present at every critical stage of their trial. Denying remote participation while knowing the defendant could not physically attend is more than inconvenient. It risks turning the proceedings into little more than a mock hearing. If a court holds hearings, calls witnesses, and sentences a defendant who lives 1,500 miles outside of their jurisdiction, while denying them the opportunity to be present, due process itself is left in shambles. Assistant District Attorney Jason White's third motion goes even further. It asks the court to revoke bond because of a peaceful, non-threatening, and non-violent Facebook comment, a political remark posted on the district attorney's own page. Yet the motion never identifies a specific bond condition that was violated. It cites no statute, no binding case law, no rule of procedure. It's completely baseless. Instead, it repeats the accusation that the defendant made public criticism. But public criticism of government is not a violation of bond. It is the very essence of the First Amendment. Unless speech rises to the level of a true threat or unlawful intimidation, it is protected. Filing multiple motions, and then amending them, without citing a single controlling authority reveals not legal rigor, but bad faith. This is not careful prosecution, it is harassment cloaked in official stationery. Perhaps the most alarming request was for a gag order. The prosecution asked the court to silence the defendant's speech because he shared body cam footage and commentary on social media. But in American law, gag orders are considered to be what they really are: prior restraints. And prior restraints are, as the Supreme Court has said, the most serious and least tolerable infringement on First Amendment rights. In Neer v. Minnesota and Nebraska, Press v. Stewart, the court made clear, speech cannot be silenced simply because it is inconvenient, embarrassing, or critical of government. Any order that restrains speech must meet the highest burden, a burden these motions don't even attempt to address. Instead, they treat political criticism as misconduct and seek to criminalize it. What emerges from these filings is a pattern: an assistant district attorney who files motions without law, a judge who proceeds with hearings in the absence of the defendant, gag orders that would silence political dissent. The office of the prosecutor itself was not part of the Constitution's original design. It grew later, often tied to enforcing human bondage and forced involuntary servitude. Yet here we see that same office today exploiting its discretionary power to overstep its constitutional bounds. Instead of defending rights, it appears intent on eroding them. The First Amendment was written to prevent this very thing, to ensure that dissent could never be criminalized, and that government actors could never wield their power to silence the people. Courts are guardians of law, not creators of it. Prosecutors are servants of justice, not architects of new speech crimes. When those truths are forgotten, the remedy is not silence, but exposure. The law belongs to the people, and it is up to the people to demand that it be obeyed.